Good morning. Welcome back to Deb's True Crime Notebook. We have another document to read to you. It looks like the defense has submitted a sentencing memorandum. If you recall, Judge Gull gave them a deadline of yesterday to submit that, and they did make that deadline. We were given access to it this morning. So let's see what they have to say. State of Indiana versus Richard Allen, sentencing memorandum. Comes now defendant Richard Allen by and through counsel Andrew Baldwin, Brad Rosie, and Jennifer Auger, and in an anticipation of the sentencing hearing on December 20th, 2024. In the above reference case number, which is cause number 08CO1-2210-MR-000001, respectfully request this court to fashion an appropriate sentence in recognition of the foregoing memorandum. Practical sentencing issues and constraints. Richard Allen maintains his innocence and is hopeful that the appellate process will provide him with an opportunity to present a full defense at a second trial. For this reason, Richard's defense counsel advised Richard Allen to not participate in providing information for the pre-sentencing investigation, PSI. The report to Allen County Probation Department as defense counsel assessed that there was no value in Richard Allen continuing to talk with state actors. There is a footnote at the bottom of this page. Here's what it says. It should be noted for the record that this court hand-selected the Allen County Probation Department to conduct the PSI and interact with Richard Allen without any input from the defense, nor any explanation as to why the Carroll County Probation Department could not conduct the PSI. Additionally, Carroll County Local Rule LROS-TR79-10 provides an analogous example of how a special judge should be selected from a contiguous county and believe that the proper methodology for selecting a special probation department appointment, should a good reason exist, would be appointing a probation office from a contiguous county to conduct the PSI. Throughout this case, Richard Allen has brought to the court's attention that he was detained in solitary confinement without due process. This constitutional violation by the state was then exacerbated by the assignment of the staff psychologist contracted by the IDOC, who, while having a deep personal interest in this case, engaged in confidential discussions with Mr. Allen about the details of the acts for which he was accused. In total, Mr. Allen was housed in 4 different jails or prisons during his detention without any input from himself or his appointed counsel. During this time, Mr. Allen was exposed to staff, law enforcement officials, and offenders, all of whom have reported circumstances which negatively impacted his defense. This is not the intended purpose of pretrial detention in our system of criminal justice. As a result of these constitutional violations, Richard Allen's defense team believes it has an obligation to protect him from the prospect of any further inappropriate contacts with the state actors. Additionally, Richard Allen is 52 years old. Pursuant to IC 35-50-2-3, Richard is facing 45 years or 130 years of imprisonment. In the unlikely scenario that under IC 35-50-2-2-2, this court would sentence Richard Allen to the mandatory minimum sentence and run the counts concurrently. On his best day, Richard Allen would receive a 45-year mandatory prison sentence. With good time credit, this would amount to 33.75 actual years in prison. This means that Richard, on his best day at sentencing, would be released from prison at 85 years of age. The practical reality is that unless this matter is reversed and retried, Richard Allen is likely facing the rest of his life in prison. Even on his best day at sentencing, Richard will be 85 years old upon his release. With these facts in mind, the defense advised Richard Allen to not participate in the pre-sentence process. Again, his continued interaction with state actors does not make sense considering that a second trial may occur which would allow him to present a full defense. Additionally, Richard will be serving his lengthy sentence whether he provides a statement to the Allen County Probation or chooses to avoid providing a statement to the Allen County Probation Department. This reality also precipitates the defense to advise Richard to not participate in the process. The defense provides this condensed sentencing memorandum considering the practical issues detailed in the previous paragraphs. Dismissal of counts 1 and 2. Double jeopardy prevents Mr. Allen from being sentenced on both his murder conviction and the felony murder conviction for Abigail Williams and Liberty German. Richard Allen was found guilty on count 1 felony murder, victim 1, count 2 felony murder, victim 2, count 3 murder, victim 1, and count 4 murder, victim 2. However, the jury convicted Mr. Allen of both the murder and felony murder of victim 1 and 2. An individual cannot be convicted and sentenced for both murder and felony murder where only one killing took place. Huffaker v. State, 735 NE 2D 214218, Indiana 2000, citing Fuller v. State, 639 NE 2D 346, Indiana Court Appellate, 1994. When a jury finds a defendant guilty of both murder and felony murder of the same victim, the court must vacate the felony murder conviction and enter judgment solely on the murder conviction. Therefore, Mr. Allen requests the court vacate his convictions for felony murder and enter judgment solely on counts 3 and 4. Statutory mitigating factors. 1. Indiana Code 35-38-1-7.1b6, the person has no history of delinquency or criminal activity, or the person has led a law-abiding life for a substantial period before commission of the crime. Richard Allen has no prior criminal history, and he maintains his innocence on this charge. Richard's lack of any prior criminal history is a mitigating factor. 2. Indiana Code 35-38-1-7.1b10. Imprisonment of the person will result in undue hardship to the person or dependents of the person. Richard Allen was the main breadwinner for the household before he was arrested and sent to Westville Prison without a hearing or attorneys present. His imprisonment has created and will continue to create a hardship for his wife of 30-plus years, Kathy Allen. 1. Richard Allen served in the United States Army National Guard for approximately 10 years, having enlisted when he was in high school. And 2. Richard Allen has a long history of mental illness, having been treated for major depression disorder, anxiety disorder throughout his life. His mental health condition was corroborated by the records of the IDOC created during his intake process at the Reception Diagnostic Center, and again through the records created by his assigned mental health providers at the prison, as well as the independent neurological exam results generated by Dr. Polly Westcott. These records were introduced as evidence at various phases during the trial, and therefore the defense requests that the court take judicial notice of the same. The defense would further request that the court acknowledge the legitimacy of his mental health condition in the guilty plea and sentencing order, so the IDOC is on formal notice of his condition when a determination is made as to how and where to confine Mr. Allen while his appeal is pending. Conclusion. Richard Allen maintains his innocence and looks forwards to the appellate process, which he anticipates will include adjudication by a neutral, detached, and unbiased tribunal. Richard Allen believes that he will be afforded due process under the law and will be permitted to present a full and complete defense at a future trial in this cause. For that reason, as well as other reasons identified herein, Richard Allen, 1, chose not to participate in the pre-sentence process, 2, will not be presenting evidence at the sentencing hearing outside of this memorandum, and 3, his attorneys will be speaking and articulating arguments in minimal fashion during the sentencing hearing. Respectfully submitted, Andrew Baldwin, attorney, counsel for the defendant. Thanks for watching Deb's True Crime Notebook. We'll reread the documents for you so you don't have to. Don't forget to subscribe, Share this video with your friends and in your groups. Ring the bell for all notifications. Give us a thumbs up on the video. It really helps with our algorithm. And we'll see you next time.